It's kind.
Mention on Monday, Mr.
But
Bhattacharya.
only one thing, my lord, this matter, my lord, Mr. Mondol and I, my lord, we mentioned jointly, my lord, 2 weeks back, my lord. So it had fallen from your lordship that if it is not taken up by the 20th, please mention it. I'll consider it.
Mention on Monday, I will let me consider.
My lord, this matter is, I am mentioning on notice, my lord, this matter is supposed to, is returnable on Monday, on 23rd, my lord. There is an urgency because the so-called contractual employees of the State Bank, they are threatening to stage a demonstration in front of the State Bank on 25th. So, my lord, some precedence may be given on Monday. I have,
Let
it's
me see.
returnable on Monday, my lord.
Sorry, there are matters, all matters are generally taken up. Let it appear. What further precedence? Sorry.
Give some upgradation, my lord. Maybe.
All the matters are taken up from the supplementary. You may not know.
No, no, that I know.
Yes. Yes, call the list.
Port Blair matter, item number 1.
My lord.
My lord, I am appearing on behalf of the
Today
respondent.
is not the mentioning date. I heard you. Today is not
This
the
is
mention.
listed for
Please
the.
don't mention today.
Sir,
Mention
this
on
is the
Monday.
item number 1 today.
Mention on Monday.
This is item number 1 today.
Port Blair matter.
No, sir.
Port Blair
My lord, I am for the petitioner, my lord. In
My
terms
lord,
of
my
the
senior
order
is
of
appearing on behalf of the
Yes.
respondent.
Just a minute. Just a minute. Yes. Whether it has been complied with.
Yes, my lord,
Yes,
it
my
has
lord.
been complied with, but my prayer for subdivision has been rejected, my lord. I am praying for liberty to take appropriate recourse to the law, my lord.
Are you in a position to place the order passed by the court, passed by the authority?
Yes, my lord, I am having the copy. Just yesterday it was sent to me, my lord. I am having the copy with me, my lord.
No, it was heard on 24th February.
My lord.
Thereafter, where is the order?
Order has been passed on 6th of March 2026, but it has been given to me.
May I have file a copy of this order so that court can see the order?
My
Yes,
lord.
my lord.
Where is that order?
My lord, that respondent contemner has to place before
So
my
no one is there here at principal bench to hand over the order.
My lord, we have complied the order, and if it
I
is
am asking
required,
him that the order is passed, whether this order can be placed before this court today.
My lord, through registry it can be placed before my lord's.
Today you are not in a position.
yes, ma'am.
I am for the petitioner, my lord. It's the contemner who have to place before my lords through registry, my lord.
I am asking the learned advocate representing the alleged contemner whether you are in a position to file the order before this court today, so
Yes,
that
my
court can see the order.
Tomorrow it can be Monday, my lord.
What is the date of order?
6th March 2026, my lord.
March 2026. Issue. Learned advocates representing the applicant and alleged contemner have jointly submitted that the order of this court is complied with, and the alleged contemner passed an order on 5th March 2026.
6th March 2026, my lord.
5.
It's 6th March, my lord.
Yes, 5th March, 5 March, 05 March.
06, my lord. 06.
06.
Yes, my lord.
6th March 2026.
my lord.
Stop. And next part, however, it is submitted by the learned advocate representing the applicant that the contention of the petitioner, contention of the applicant is refused
My lord.
by the said order dated 6 March 2026, requiring necessary steps to be taken. Next paragraph. In view of such submissions made on behalf of the parties, contempt application is disposed of and contempt proceeding stands dropped. However, this order shall not preclude the applicant to take steps in accordance with law against the order dated 6 March 2026.
I am grateful, my lord.
Much lodged.
Urgent Xerox certificate copy.
I am grateful. I am grateful.
Item number 1 from daily list.
এটাই assigned. Who is appearing for the respondent? Issue. Matter is accommodated in today's list under the heading.
Miss Sonal Sinha is appear, Mr.
Matter is accommodated
praying
in the
for
list
not to
under the
respond.
heading. Please hear the order. Matter is accommodated in the list under the heading to be mentioned after the matter is assigned by the Honorable Chief Justice. Video order dated 18 March 2026. Next paragraph. Today, you are appearing in person.
In person, sir.
Today, petitioner is appearing in person, but respondents are not represented. Next paragraph. Petitioner is directed to serve notice upon the respondents or the learned advocates representing the respondents, including copy of this order by 10 days from date, and file affidavit of service on the next date.
My lord, 10 days will be enough, more than enough. Actually, my
Paragraph
petition
list-
become infructuous.
The matter under the list the matter very well by 7 days. Stop. List the matter under the heading motion assigned on on 30th March 2026.
30th March, my lord. It will be my petition become infructuous, sir, in that case.
Sorry. Yes, next matter.
Item number 2.
I'm appearing for the petition. A further assessment was made by the, because 168.
My lord, yes, my lord, in 7 lakhs and we have my lord, erased the money of 3 lakhs.
Just
দেখেন, 3 লাখ টাকা
whether I have whether I can take this matter in
Hello?
view of change of determination.
চেঞ্জ অফ ডিটারমিনেশন না না
For appropriate order. No, it has been assigned to me.
It was assigned, my
If
lord.
it is assigned as per determination, then I do not.
Then,
have
my lord,
determination.
no
The
objection.
Or
further,
before the regular bench,
my lord,
as it has been done in the previous matter.
my lord.
No, it is by name, it has been assigned.
It was assigned, my lord. My
Just,
lord, this is
Only
long
last-
pending, my lord, since 1996.
Yeah.
Let it be, my lord.
Because now Lashes I convinced my
just a minute, just a minute. I will hear both of you. Assessment was made previously, remember.
161.
Yes, 1 crore 7 lakhs.
এখন কত হয়েছে?
1 crore, yes, 1 crore 9,85,000. সাবস্ক্রিপশনটা বলে দিন।
হ্যাঁ?
সাবস্ক্রিপশনটা
হ্যাঁ, বলে দিচ্ছি।
বড়গুলো তো দেবে, এখানে লিখতে হয় মেজর মাইনর এগুলো সব লিখে দিতে হয়। অল
নিয়ম মাফিক এগুলো করতে হয়, এখন করেনি তো আর কি করে, এগুলো সামান্য ও লিখেছে পেরা,
প্যারাগ্রাফ একটা স্টেটে লিখেছে অল
লিখেছে।
মেজর সুইচ,
অল আর মেজর।
কিন্তু এই যে এখানে না, এখানে লিখতে হয় এজেড অ্যাবাউট, এখানে এজ।
না না, এখন আর হয় না। এগুলো হয়ে যায়, এগুলো উঠে যাবে, এগুলো নিয়ে,
ঠিক আছে, আমি ওটা অবজেকশন দিচ্ছি না।
ওগুলো নিয়ে কোনো অবজেকশন।
So primarily it was 168 decimal and the value was assessed
Yes.
60,70,303.
My-
Subsequently, it was enhanced.
Well, today, my lord, I am submitting the enhance 60 lakhs to, my lord, it is now 1 crore 9 lakhs.
So it was previously after direction passed by this court to quantify the valuation of the land appropriately, taking note of the area of the land as well as the market value.
My lord,
Then it was
1 lakh
it
7.
was yes 1
1 crore
7 lakhs 92,000.
Yes.
Now it has further been enhanced.
Further enhance, it is 1 crore 9,85,000.
As per their measurement, 168, our measurement of the land is 185. And Lordship in on previous occasion says, yes, I will, because it is certainly the pending. In future, certainly they will settle the problem, but that at present, Lordships, he is agree that yes, 168, what is the today's assessment, Lordships, he will accept. And
But
before,
it is to be recorded in the order that they are disputing the area.
disputing area, yes, 168, but actual measurement of the land is 185. And Lordship says, yes, because if there is any dispute, rest of the land, certainly I will the keep pending at that point. In future, they will raise
Now,
this point.
take me to the original order passed because today final
My
order
lord,
is.
This is a
according to the original order, there are recording and they have admitted.
Yes, that I have to see
My
in
lord.
order to pass the final order. Where is that order?
ওই justice ইয়েটা অর্ডারটা চাই।
Order was passed by Justice N.K. Mitro, as his lordship then was.
My lord.
4th October 1996. That orderটা দেখেন ওনার।
It is annexed to the contempt.
হ্যাঁ, annexed to the
এই
content.
contempt
Annexed to the
এটা
contempt.
কোথায় দাও এবার?
My lord, in the paper books, perhaps.
পেপার বুকে দেখান না ওনাকে কোনো এটা
এটা দিয়ে দিন, এটা দিয়ে দিন।
এটা
Yes, just a minute.
4th October. প্লাস্টিক কি বলেছিল?
জমি ফেরত দিতে হবে।
4th October 1996.
My lord. আটটা দিন। তার একটা দিন।
বলে দিয়েছি এত কবের থেকে বলতে, দেখি আর কি হবে, তো এমনি ইন্টারেস্ট নিলে তো বিরাট ব্যাপার। হ্যাঁ,
না না, এটা তো কারেন্ট মার্কেট ভ্যালু আপনার 18 ফেব্রুয়ারির মার্কেট ভ্যালু।
গত 18 ফেব্রুয়ারি দিয়ে দিয়েছে।
18 আপনার তো 26-এর মার্কেট ভ্যালু দেখাচ্ছে। এখনো তো রেকর্ডে তো এটাই রয়েছে, পুকুর পাড় সোনা 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 শালিক।
এখনো তো এই
এই দেখো।
ও কালকে আমাকে বলছিল যে এটা তো
রেকর্ডটা
শোনাই
তো
রয়েছে।
রেকর্ডটা এটাই আছে,
আপনি বাস্তু তো নয়।
বাস্তু কোথাও দেখা নেই। আর ওই যারা ঘর করেছে ইন্দিরা করেছে,
এইভাবে করেনি কে?
ওই কাজ ঠিক
এসব তুলছি না।
এই
পেয়ে গেছেন অর্ডারটা, আর দরকার নেই।
Now, the area of the land was 168.
185.
No, assessment has been done in respect
Assessment
of
168, only 168.
168.
decimal.
Decimal.
1 acre or 68, sorry, 1 acre 68.
ওই 1 acre 68, যাই হোক 168 decimal। ওই একই কথা।
1 acre 68 decimal.
So
The
there is
same.
168 decimal.
168 decimal, right?
No, no, 1 acre 68. Oh, 160.
একই কথা রে।
Yes, yes, same thing.
168 decimal।
Same thing. 168 decimal. My lord, may I have kindly, my lord, my junior is
And
here.
schedule A is concerned 185.
And according to you, it is 185.
185. It is not according, it is schedule A
But
of
at
the
least
land.
in the
Yes.
10 orders. it
Oh,
is-
that 10 orders, it is not. But it is, if I raise this point that
Yes,
that
yes.
assessment was not made in proper manner, so I can, but I will not.
My lord may grant you liberty to agitate that point.
Yes, that point will be kept open. If
Huh.
petitioner wants,
The last
petitioner
day,
may
last day, Lordship.
approach in accordance with law with regard to quantification of the area of the land in
Area
question.
of the-
Yes.
My lord, may I have kindly, my lord?
Yes.
My junior
And
is
Lordship,
here.
one substitution petition.
Now,
Lordship.
where is the recent, the last
No, no, no,
assessment?
just now I have made over.
Just a minute, Mr. Mahata. Because this is continuing for pretty long time.
My lord,
So wait for some time so that yes, where is the assessment?
my lord, in the second page, my lord.
1 crore 9 lakhs 85,140
140
is the assessment made by the authorities.
by the authority, ADSR.
District Sub Register Pandua Hugli.
My lord,
Esho.
my lord, may I have kindly, my lord, another matter I am.
And one substitution petition I will
If
file
court
because of one
requires, your junior will call you.
My lord, one substitution petition.
petition
is
because
there.
the petitioner number 8, my learned friend's mother, Lordship, that died on 14 February 2026.
I have number of occasions allowed substitution application.
No,
How long this will
substitution
continue?
now, just now, Lordship, after
Yes.
14 February, his mother. So Lordship substituted some petition.
Very well. You indicate me after dictating this order.
My lord. Deeply, my lord, I am coming.
This contempt application is being heard by several benches for a pretty long period of time, as the allegation is violation of the order dated 4th October 1996. Passed on a writ petition being CO number 10179W of 1996 by NK Mitro J. শুধু J হবে, হ্যাঁ? Stop. The coordinate bench, video order dated 4th October 1996, recorded that there was annulment of patta granted in favor of third parties, requiring land in question to be returned to the petitioners. Stop.
Within the 4 months, দিয়েছিল না টাইমটা? Stipulated period. Huh? 3 months. 3 months এর মধ্যে।
Further directed the concerned respondent authorities to start appropriate proceeding for annulling pattas granted to the third party in connection with the land in question and deliver the possession back to the possession of the said land back to the petitioners within a particular time. It was further directed that persons in whose favor patta was granted were required to be accommodated in terms of the directions as contained in the said order dated 4th October 1996. Stop. The writ petition being CR 15469 of 1999 was filed by the applicants seeking implementation of the was filed for violation of the said order, that alleging violation of the said order dated 4th October 1996, thereby directing the authorities to take steps in accordance with the direction of the coordinate bench. Stop. However, during course of hearing, it was found that the land which was settled in favor of the third parties, though patta was annulled, was already utilized by the third parties by making constructions, and the third parties are staying there. Constructions have been staying there, as a result whereof Mr. Brahmo, you are appearing for last 3 occasions. As a result whereof alleged contemners found it difficult to comply the order dated 4th October 1996 in its true letter and spirit. Stop. Matter was heard on number of occasions, and then we pay to that. On 14th November 2025, matter was heard টা পরের প্যারাগ্রাফে হবে কিন্তু, হ্যাঁ, তুমি সেই রেলগাড়ির মতো সব চালিয়ে মাথাটাও কাটাবে। Matter was heard on number of occasions, and on 14th November 2025, the learned government pleader representing the alleged contemner mooted a proposal of paying value of the land in question to the applicants on proper assessment based on the area of the said land and its market value. Stop. Learned advocate representing the applicants prayed for accommodation to obtain instructions. Subsequently, matter was taken up on December 5th, 2025, when the learned advocate representing the applicants submitted that if appropriate quantification of the valuation of the land in question was made by the concerned state respondents and same is paid to the applicants, they are willing to accept the same. They are willing to accept the same. They are willing, or they were willing to accept the same. Next paragraph. Based on such stand taken on behalf of the applicants, additional district sub-register Pandua Hooghly was directed to quantify the valuation of the land in question, taking note of the area of the land and its present market value. Stop. After exercise was made, after prolonged exercise was made by within bracket করে দাও ADSR Pandua Hooghly. After prolonged exercise was made by ADSR Pandua Hooghly in several phases, finally valuation of the land is assessed at rupees 109,85,140. Stop. It needs to be recorded herein that such assessment was made taking note of the area of the land 168 decimal, though applicants claimed the area of the land, or though applicants claimed said land comprises of 185 decimal. Stop. Next paragraph. Today, Mr. Gautam Bromho, learned advocate, representing the applicants on instruction submits that applicants are willing to receive the valuation of the land or willing to receive the price or willing to receive the valuation of the land as assessed by ADSR Pandua Hooghly. But Pandua Hooghly, stop. In same breath, it is also submitted that assessment ought to have been made based on area of the assessment ought to have been made considering area of the land in question, that is 185 decimal, not 168 decimal. Stop. However, it is submitted that keeping the issue relating to area of the land alive, petitioners, applicants are willing to accept the valuation of the land, accept the price money of the land as assessed, accept the price money of the land as assessed by ADSR Pandua Hugli. That is rupees 109,85140. Next paragraph. It needs to be recorded herein that though VDA order dated 4th October 1996, while disposing of the writ petition, coordinate bench directed to return the land in question to the applicants upon completing the process of annulment of patta of the land, or upon completing the process of annulment of patta, but taking note of the subsequent developments, that is the subsequent developments, court finds that compliance of the said order dated 4th October 1996 in its true letter and spirit is not possible, and it was submitted and it was agreed on behalf of the applicants to accept the price money of the land in question on appropriate assessment. Stop. Stop. After grant of patta, which was subsequently annulled, third parties made constructions over the land in question, as a result whereof alleged contemners found it difficult to return the land in question to the applicants. Next paragraph. In view of aforesaid scenario, concerned state respondents, including the alleged contemners, are directed to pay the price money of the land as assessed by ADSR Pandua Hugli, that is rupees 109,85140, to the applicants
To the person possession taken over with the Shalil Kumar Mabdar.
proportionately, to the applicants proportionately by 4 weeks from the date of communication of this order.
4 weeks. Lordships fixed that on date, and the check on price money of the will be delivered.
No, it has to be paid by proportion, because there are several applicants.
But
Court did not enter into this.
possession taken over in respect of schedule of property only by Shalil Kumar Mabdar on behalf of all others, because
No, there are many applicants today.
many applicants.
Not Shalil Kumar Mabdar, there are many applicants, and they are to be paid by in its appropriate proportions, by appropriate proportion. Otherwise, the order will not be, it will not be an appropriate order. Suppose there are 20 claimants, they are to be paid considering their right over the area of the land in question.
Otherwise, Lordship, because the number of petitioners.
So that's why I have directed that 4 weeks time. That's why I have directed 4 weeks time. It will, I don't think it will be complete by 4 weeks. It will take longer time. How many applicants are there? Tell me from your contempt application. দেখি contempt application এইখানে না, এর আবার একটা আলাদা মানে এত amendment হয়েছে
30 numbers. এখন after substitution.
There are 158 petitioners.
One settlement bid is there because the
Today also you are moving on substitution application. So what authority will do?
30 within substitution 30 number, because my learned friend says yes, one settlement settlement deed was made between the petitioners and Sholil Kumar. হ্যাঁ? আপনার নামটা কোথায়? দিয়েছে তো। দেখুন এটা যদি করতে পারে তো দিয়ে দিক, 4 weeks এর মধ্যে যদি দিয়ে দিতে পারে।
এডিএস আর হুগলি পান্ডুয়া যে অ্যাড হলো পরে সেটা কোথায় লিখলো? সেই পেজটা সেটাই যে খুঁজছি, কোথায় দেখো তো এইটা।
হুম? না না না
Who is to pay?
Lordship,
Which alleged contemner is to made such exercise?
District Land and Land Reforms Officer,
Block Land and Land Reforms Officer.
ADM dealer.
Yes, block land officer, subdivision. So district land and land reforms officer would be the appropriate authority.
but is it possible, Lordship, the all petitioner to appear because number of
Yes,
petitioner is
yes.
bedridden now.
Yes, they have to assert their right. Otherwise, how the payment is to be made?
Because they have.
No,
given the
I'm not
court the
going to
power.
direct that this check is to be handed over to the learned advocate.
No,
Sorry,
Learned-
Sorry.
No, by
sorry, no. As per their right, proportionate amount is to be paid. কি বলছিলাম দেখো তো? না, আবার পড়ো এই সেন্টেন্সটা। না, in view of aforesaid scenario, this present district, who is the present district land and land reforms officer? Purnendu Kumar Majhi.
Tamil India. Is Tamil,
Yes,
is Tamil Obia.
whether the present district land and land reforms officer is party?
has been
Which respondent?
five people. দেখো তো 5
Tamil Ovia.
তামিল অভিহা।
আচ্ছা, কি বলছিলাম বলো? In view of aforesaid scenario, present district land and land reforms officer Hooghly, MS Tamil Ovia, OVIYA hyphen capital S is directed to কি তারপর কি বললাম দেখো বলে দিয়েছি।
বাংলা বোঝে হ্যাঁ? তাহলে তো হয়ে গেল, ঠিকই আছে।
Proportionately
By 4 weeks from the date of.
না 4 weeks to 8 weeks করে দাও। By 8 weeks from date.
8 weeks.
By 8 weeks from date. Stop. I thought today I will dispose it off.
Election has come, not 8 months, certainly 12 months. So 4 months and 6 months. Lordship. Huh?
Election will be intervening. There will be difficulty.
Very
There will be
difficult.
difficulty.
Very difficult.
SIR is going on. Election is intervening. There is difficulty. এটাকে 10 weeks করে দাও।
Yeah.
Now she is there as district land and land reforms officer.
Election period here change or not, I do not know.
By 10
Give
weeks.
me 2 weeks time so that I can.
No, sorry, there are other matters.
Or any person incompetent in place of whom it is not possible. In same place, same rank, any person. So certainly
তাহলে একটা কাজ করো ওই সেন্টেন্সটা একবার বলো প্রেজেন্ট ডিস্ট্রিক্ট ল্যান্ড এন্ড
present district land.
পড়ো ও ঠিক করে দিচ্ছি তুমি নাহলে তোমার মাথায় ঢুকবে না পড়ো ওটা কেটে দাও নামটা দরকার নেই হ্যাঁ ঠিক আছে যা আছে তাই
And
স্টপ
and substitution petition which has been filed, that it should be allowed. That should be allowed. Otherwise, Lordship, there is no who has come.
Who are to be substituted in whose place?
Is petitioner number 8. Petitioner number 8. Hornalata Mabdar.
Petitioner number 8 died.
Petitioner number 8 died. 14 February
No, 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 no.
2006. Five sons and 2 daughters.
Just. Next paragraph. One application being Can 3 of 2026 is also taken up for consideration seeking substitution of parties in view of death. Due to death of applicant number 1, Swarnalata Mafdar, MAFDAR.
Eight-
Swarnalata
eight
Mafdar, when died?
8 বলেছে।
When died?
14 February 2026.
86. On 14th February 2026. Stop. It is submitted that heirs of said Swarnalata Mabdar are major and sui juris. Stop. Next paragraph. Application being Can 3 of 2026 is allowed, thereby directing the department to incorporate names of the
Cantuta key.
heirs of Swarnalata Mabdar being applicant number 8 in the contempt application in terms of paragraph 4 of the application in place and stead of the said applicant number 8 in the cost title of the contempt application by 10 days from date. Stop. The application being Can 3 of 2026 is allowed and disposed of. Next paragraph. In view of aforesaid directions passed in the contempt application is also disposed of.
There is no other can number, no? Can number 2. Can number 2. কি সেটা?
If any other applications are pending, those are also disposed of. I am disposing of it by 10 weeks. It is to be completed.
That point was because others point is at the open. That point.
আচ্ছা না
Because-
ঠিক বলেছেন এই
একটু আর বলা।
অ্যাপ্লিকেশনটার আগে আরেকটা প্যারাগ্রাফ পড়ুন However, it is made clear that if applicants have grievance relating to
এটা তো বলতেই হবে।
the area of the land in question, which area of the land in question that is 185 decimal instead of 168 decimal.
এগুলো বলছেন না, এগুলো আমাকে বলেন। সবই ওখানেই হবে আবার কি আমারটা মানিটা উনি বলবেন কি
Comma, they shall be at liberty to approach the appropriate forum for further determination of the area of the land. Stop.
ব্যাস হয়ে গেল এটাই তো বলবো ক্যান্টিনটা তো সব ডিসপোজ করে দিল এনি ম্যাটার সব ডিসপোজ হয়ে গেল গ্রেটফুল টু লর্ডশিপ সবই তো হয়ে গেল আবার কি চান আপনি?
ধরে করবো
ওইগুলো কোথায় এখন
Item number 3.
কত নম্বর হলো
Lordship, I appear for the petitioner.
I am for the contempt. Well, my lord, may read your lordship's last order, para 4, my lord, para 4.
Yes,
So far as the
complete demolition.
my lord, I'm placing. It is going to be complete, but fact is this, certain serious cracks have been taken place in ground floor and first floor. Now, my lord, we are going for repairing of the cracks. My
You
lord,
are repairing the cracks.
yes, my lord, we have to.
Lordship, no repair work is being carried out as
there
has
any
been
crack?
submitted. Not to my information. I have no such
Information,
instruction.
my lord, then
I
my
have no
lord,
such instruction.
then my lord,
No, no,
appoint a
Lordship.
special officer.
Lordship, I have
Then it
one
will
thing.
be clear, my lord.
Lordship,
How can we? My lord, I have given the photographs. What type of
you have made your submission now.
আপনি কি করতে চাইছেন? আমরা তো ভাঙা চলছে।
But from the photograph, it appears that there is substantial demolition.
Substantial demolition.
Lordship, if I may submit this, Lordship, the premises in question is nothing but a G+4 structure, out of which second, third, and fourth floor has to be demolished.
No,
The
second,
order,
third, fourth and fifth.
okay, second to fifth, it has to be demolished. Now, Lordship, the order is of January 24. We are in March 26. Every month we are before your Lordship. I have filed a contempt petition. My learned senior friend appears and he says that that demolition work is going on.
Let me direct that the entire house be demolished.
Yes, that is better.
Better.
Yes, let
Then it will be
them,
very well.
at least,
Let them,
yes,
File an affidavit.
well,
to
let
that
them,
extent.
let them vacate it.
yes.
You file an affidavit.
Let them vacate it.
Let the applicant.
I'll
It is
take,
very
I'll
easier
take
for
that,
us. I
I'll
will
take
take
that
only one
instruction.
month.
Applicant file an
Lordship, I'll
affidavit
take
that
that
the
instruction.
entire structure from the
Yes,
ground
yes.
floor be demolished.
Then let them.
Then it will be completed by 30 days.
Lordship,
Not
even then it
30,
won't happen.
15 days, ma'am.
Lordship,
You
that
file,
also
you
won't
file an
happen.
affidavit. See,
Okay, let me seek that
don't say
instruction.
okay before this code. It's not.
Lordship,
a
I'll
clear
take
one.
that instruction. I'll take that
You take
instruction.
instruction
Very
that
easy.
whether the entire building
Then
is
your
to be
Lordship will
demolished or
keep it
not.
on Monday itself. Your Lordship will keep it
Monday.
on Monday. I'll
Then
come
I
back
will
with
keep it
instruction.
that it is up to this court. But are you confident that he will get an instruction from the applicant that the entire building is to be demolished, including the authorized part?
Lordship, instruction I will get. As regards affidavit, I will need 1 day or 2 days time. So
You are not staying there.
no, I am not.
Who is staying?
Yes, they are staying.
I am not staying. My clients are staying. Yes.
Clients are staying.
Huh. They are a resident
You
of the
means
ground
not
floor.
not the learned advocate.
Yes.
You means the applicant.
Yes, the applicant is staying in the
Applicants
ground.
are staying there. Where they will go if the entire house is demolished?
Lordship, that was never my submission. My submission
I am
is with
asking
respect
you that you will make a the applicants will affirm an affidavit disclosing stating that and
Lordship-
averring that the entire house be demolished
Lordship,
for
that
in order to
instruction I have
expedite
to
the
take.
process.
Lordship,
In
that is
Hear
not my
this quote
submission.
first. Hear this quote first.
Yes, Lordship.
In order to expedite the process, entire house be demolished, including the authorized ground floor and first
Grateful,
floor.
grateful.
If that is demolished, then where the applicants will stay?
Lordship, I have to take instruction. That's
No, I'm
not-
asking where the applicants will stay. Be reasonable before this court. Don't make absurd submission or preposterous submission before this court. So, since applicants are staying in the authorized part of the building in a congested area in Howrah, in first ground and first floor, where they will go if the entire house is demolished?
Lordship, that's never my submission. That's never been my
You
submission.
are saying that yes, that is possible, and I will.
No,
find-
no, Lordship. If I have made the submission, I'm taking back that submission. That's never been my submission, Lordship. My submission is only with respect to second, third, fourth, and fifth
There
floor.
is a problem because keeping this first ground floor and first floor intact
Extra 4 floors, man.
and without causing any damage to ground floor and first floor, rest of the 3 floors are to be demolished. There is a difficult. That's why the demolition process is being delayed. Court is not saying that
40
it is
years
not to
building,
be
man.
demolished,
40 years.
but that reasonable time has to be granted in order to protect your part
Yes,
of the building where
Grateful,
you are
grateful.
staying.
Grateful, Lordship. Now, on this also, may I submit one thing, Lordship? Lordship, just one last submission.
Matter is hard in presence of the learned advocates. So when cracks will be repaired and the
It
demolition
will be
is-
repaired by 2 weeks. 2 weeks repaired. Thereafter, again the demolition will continue, and demolition is continuing every day.
But it's very slow. Progress is very slow.
No. Demolition is continuing. I'm sorry, man.
Because last
I
occasion-
shall not say no.
Last occasion, Assistant Engineer, Demolition Building Department, Howrah Municipal Corporation was present before this court, and he
Yes.
prayed for 30 days time.
He was present because my lord has not called
And
him.
he prayed. Yes, that I remember.
My
But he
lord,
prayed for 30 days time.
only
I
because
have
of that,
recorded-
I have called him because he would explain it before your lordship. He was very much confident that it will be completed. But it is a 20 to 30 years building. old building, 4 extra floors. He was immediately when cracks have started, their clients have pointed him out that be serious. These are going to be cracks are there. Then he said, because contempt is running, he said, I am repairing the cracks and then I will start the again.
Issue. Matter is heard in presence of the learned advocates representing the applicant and alleged contemners. Next paragraph, Mr. Sondipon Banerjee, learned advocate representing the alleged contemners, has submitted substantial part of the building in
Okay,
question,
she's from the photographs itself.
which was found to be, which is declared unauthorized, is demolished, but demolition work is not complete. Stop. It is
Only 20%,
stop.
10%.
It is stop. It is please don't interrupt. It is reiterated that on behalf of the alleged contemners that keeping ground floor and first floor of the building in question barring ground floor and first floor of the building in question, rest of the floors, that is second, third, and fourth.
Second, third, fourth, fifth.
The rest of the floors, that is
And
second,
huge debris is being
third,
stacked.
fourth, and fifth floors are to be demolished. Next paragraph. As a result whereof, extra caution is being taken so that no damage is caused to the ground floor and first floor of the building in question
30 years
at the
old.
time of demolition. Stop. It is submitted that during demolition, during demolition work, certain cracks are generated in the first ground floor.
And
Ground
pointed
floor,
out by the
where it is generated.
ground floor and first floor.
In
And
ground
pointed
floor
out by
and
the
first
petitioner
floor of
itself.
the building in question,
আপনি একটু জিজ্ঞেস করবেন।
which are required to be repaired after repaired for completing the demolition work. Next paragraph, on behalf of the alleged contemners, it is submitted that that repairing work is to be completed by 2 weeks from date,
2 weeks repairing her.
and thereafter demolition work will commence, and which will be completed by 30 days thereafter. Next paragraph. In view of such submission made on behalf of the next paragraph, learned advocate representing the applicant prays for early demolition of the unauthorized part of the building in question in terms of the order passed by this court on the connected writ petition. Next paragraph, having considered the submissions made on behalf of the respective parties, hearing of this contempt application stands adjourned in order to enable the alleged contemners to complete the demolition work. Next paragraph lists the matter under the same heading for further consideration on in the combined monthly list of June 2026.
And I will
Or in the combined monthly list of May 2026.
I will come with a compliance report.
Not June, May.
Item number 4.
I'm for the petitioner.
Complied with.
It's the process.
Again, it is free.
Debris removal.
So by one day, the debris can be removed.
It's being done. It's being done. Almost 70% of the debris.
60% has been done, 40% is remaining. I have the latest.
He's saying 70%, you are saying
I have got the latest photographs and the video in my
question
mobile.
is,
If your lordship wishes
why you are
to
taking so much time?
My
When Mr. Mukherjee is appearing?
lord, the staircase is in a very bad condition. The people have to take the load on the head and come down the staircase. They are scared that if they sleep, they will die. It's in such a condition, the building in such a condition. So the work is slow.
Tell me how much time would be required.
My lord, keeps in the month of May. Like the other matter, your lordship.
No, that is a different thing. Don't relate your matter with the other matter.
I was just,
No, no, no.
no, that is also illegal
7 days.
construction.
Mr. Mukherjee, 7 days.
Huh?
7 days.
At least your lordship keeps it in the month of second week of April. Second week of April. And the report may be taken on. A last chance.
Esho. I will consider the report when the entire demolition, entire work is complete.
Demolition is over.
Not
It is now-
demolition, entire work is complete.
Yes. Removal
Regarding
of the
removal
debris.
of debris, which
Removal
is
of the
piled
debris.
up at the site in question. So you take back your report, file and
Your lordship keeps it.
file affidavit of compliance.
I'll do that. Your lordship takes it on record. I'll file an affidavit of compliance. Your lordship keeps it in the third week of April.
Mr. Bishwajit Mukherjee, learned advocate representing alleged contemner, has prayed for further time to remove the debris from the site in question. Stop. A writing dated 12 March 2026 of executive engineer within bracket C, close bracket, building department, Kolkata Municipal Corporation, is placed before this court and same is taken on record. Next paragraph, applicant is represented by land advocate who has prayed for direction for early removal of debris pursuant to the order passed by this court on the contempt application. Next paragraph, hearing of this contempt application is adjourned in order to enable the applicant, in order to enable the alleged contemner to complete the work. Work of removal of debris from the site in question. Next paragraph, list the matter under the same heading for further consideration in the monthly combined list of May 2026.
Great. Much of
Grateful.
Item number 5.
For the petitioner.
I beg to appeal for the respondent number 8. I am praying for a very short passover in this matter. My lord, Mr. Vishnu Bhattacharya is leading me. My lord, he is engaged before the division, which kindly allow me 5 minutes passover.
I can start.
Who is appearing?
Vishnu Bhattacharya is leading me, my lord, in this matter. On behalf
They
of
are appearing for whom?
my lord, respondent number 8, Punjab National Bank.
Whether the all respondents are represented today?
I don't know, my lord,
That's
whether they are
not-
served or not.
When you have served?
I think, my lord, respondent number 9 is also the, my lord, necessary respondent, my lord.
Whom is service, Mr.
This is my evidence.
When it was service was effected? Find it out.
Yesterday I mentioned this matter.
Give further time.
But,
Give further time.
yesterday I mentioned this matter. State is
The
appearing.
respondents are not represented.
State-
Give further
all are
time.
represented.
Come back on next Friday.
My lord, one
All
more-
are representing.
One more prayer, my lord.
9 is not represented.
9 has no role to play. 9 has no role
So
to
then
play.
expunge 9 from the array of applicants.
Can.
At this stage,
Allow me,
when
yes.
the application is writ petition is pending.
My lord.
At this stage, when writ petition is pending,
My lord,
But
one
because they are
that
mortgaged,
matter can be hard to
they
get.
have mortgaged the property to the
my lord,
bank.
one more prayer I have, my lord. We have also filed, bank has also
Next
filed a-
Friday, Mr. Next Friday.
my lord, one more prayer, my lord. Bank has also filed a writ petition, my lord.
Um,
Let it be, listed
Take back your affidavit service filed on the next day, next Friday. Next matter.
May I take back the opportunity? Maybe service.
Simply next Friday, it will appear in
I'm
the
I'm
supplementary.
get
এবার কি কম্বাইন লিস্ট কম্বাইন লিস্ট হ্যাঁ ডাকো কোনটা ডাকছো 100
Item number 6.
798
My lord, may I be already to meet?
just a minute
বলো না তুমি সরো দাঁড়াও চলে যাবো 6টা উইথড্র হবে 6টা উইথড্র করে নেবো হ্যাঁ
yes 798 ডাকো
মানে নেক্সট ম্যাটার
let the matter be called on.
Item number 798 from monthly list of appellate side. My lord,
Why you are mentioning?
No, anything, no, my lord.
Sir,
Next
withdraw.
matter, my lord, may I be permitted to withdraw this application, my lord, but there are some.
Next matter means, next matter from the combined list.
Six, no, my lord, next six.
When it will be called on, then it will appear.
That is true.
Matters have to be taken up as per the rider in the list.
That is true. That is true. I am not mentioning.
My lord,
Service is complete.
My lord, I'm for the commission led by Mr. Bandopadhyay. He's on his legs before courtroom number 11, praying for a short passover.
Short passover is not possible. Yes.
My lord,
Where is Mr. Dasgupta?
my lord, my lord, Mr. Dasgupta is also before another court. My lord, but I can continue. I can start. My lord, he will.
Not today. Next Friday. Let it be in the monthly combined list of May. There is no such urgency. I know this matter. At the time of call, accommodation is prayed for on behalf of the learned advocates representing the applicants and alleged contemners. Stop. Hearing of this contempt application stands adjourned. List the matter in the monthly list the matter under the same heading in the monthly combined list of April 2026.
April.
Next matter, please.
April.
item number 806.
Lord, I am for the petitioner, your lordship.
আচ্ছা এটা determination নেই তাই তো old contempt
হ্যাঁ
it is to be released. I do not have the
আবার চেঞ্জ হয়ে গেছে
এসো
ছেলের কপালটা ভীষণ খারাপ
matter stands released due to want of determination and be placed before the appropriate bench.
matter is running in the list of combined list, your lordship.
Yes, wrongly running because I do not have now the determination to take
Change.
up the old contempt.
I should have checked. Even I have not
Yes.
checked. Lordship. হলো না তারপরে এটা আমার প্রাইভেট মামলা অনেক দেখি
Item number 6 from daily list.
Item number 6. This দিয়েছে রে বাবা You are for the state. At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, state respondents are represented by learned advocate. Next paragraph, list the matter under the heading motion in the monthly combined list of April 2026.
Great.
Yes.
Item number 7.
This is my application.
Yes, who is for the petitioner?
I was petition.
Yes.
But this is a case, my lord. But I am the Sebite and others of a Mandir, my lord. My lord, we are performing so for the last 100 years, my lord. Now, my lord, the respondent private hearing, they are the local hooligans, other things. They are trying to capture the Sebastian from us. Not only that, they have also used my lord.
What about the private respondents?
When
served? Find out when served.
Man, they have accepted, my lord.
When served, please find out.
17/3. 17th.
Come back after some time. Today is 28/3. No private respondent is represented, and it appears that It is a dispute between the petitioner and the private respondent.
No civil dispute, no, there's other things. Very. Then, lordship.
17th March and today we are on 20th of March. And it is in Purbo Medinipur.
Very well, then, if you lordship on the 24th, 24th.
At the time of call, file your affidavit of service.
Yes, ma'am. This is
Affidavit of
very
service filed on behalf of the petitioner is taken on record. Next paragraph. At the
Personal
time,
record
next
that,
paragraph. Those state respondents are represented, but private respondents are not represented today. Next paragraph. List the matter under the same heading for further consideration on 27th March 2020.
After difficulty, then,
Yes.
27 after difficulty, man. 26 or
Then
27.
let it be in the combined monthly list of April.
No. 27 March. No. I have some year, 27 March. There's some difficulty, so I have appeal loss.
Next matter.
Item number 8.
Item number 8, I am for the petitioner, Lordship. This is my affidavit of service, Lordship. Lordship, the petitioner is the owner of the land.
Other side.
Already served, Lordship.
When served, find it out. State is not represented.
19/3 of 26 are delivered, Lordship.
19/3
March. 19 March and 26.
Now, there is no 48 hours notice, which is required as per the REIT rules. So why you have given this date? I am asking everybody. The matters are coming as per presentation form. You take more 7 days more, 10 days more to ensure completion of service upon the respondents.
Lordship, please come to the page 26, Lordship.
I will come later on, but you have to serve upon the respondents. You are not in a position to complete service.
Already served.
48 hours notice is not over. 48 hours period is not over, and matter is being is appearing in the list as per presentation form. So let it go appear before the combined list of April 2026, so that you can complete service.
Yes, Lordship.
Have you served upon the government pleader?
Yes, Lordship.
Show me that you have served upon the government pleader. देखी दाओ तो सर्विस 17th March. Affidavit of service filed on behalf of the petitioner is taken on record. However, state respondents are not represented. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by 24th March 2026. Stop. List the matter under the same heading for further consideration on 27th March 2026. You find out who is appearing for the state respondents from the office of the government pleader, serve me a notice and come back.
Yes, Lordship. Grateful.
Item number 9.
9, I am for the state respondent, my lord.
Petitioner?
Though I have, my lord, received the...
Who is appearing for the petitioner?
I'm not finding, my lord, but I have received a secured a report.
It's not required. I have not called for any report. Who is for the petitioner?
Mr. HON'BLE, the advocate.
Issue. At the time of call, no one appears for the petitioner, and no accommodation is paid for. However, state respondents are represented by land advocate.
Respondent. Petitioner
State respondents are represented by land advocate. Next paragraph. List the matter under the heading motion in the monthly combined list of April 2026.
And lots of direction.
You are not a party. When matter will be called on, you renew your prayer.
Item number 10.
Only one thing, may I be permitted to hand over the copy?
No.
My lord, I am for the petitioner, my lord.
Yes.
I have sent all to 17th, my lord. They have not received. I have checked the track record, my lord. It's not dead.
Service is not complete.
No, my lord. The state has been served by hand.
You have sent on 17th, and how it will be complete?
My lord,
Why you have given this date? 20th of March.
My lord, due to some problem, I could not send before, my lord. 17 I have sent, my lord. It will.
Yeah, for the state.
My lord. No, I'm ready with the report.
Issue. At the time of call, learned advocate representing the petitioner prays for accommodation to complete service of notice upon the respondents. However, state respondents are represented by learned advocate. Stop hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 27th March 2026.
My lord, any date except 27, my lord, any date. Any date except
Why?
27. My lord, I'll be out of station to my son in Mumbai.
30th March 2026.
Grateful, my
lord. I'm sorry, my lord. I'm paying apology, my lord.
Next matter.
In item number 8, Lordship, state is here, Lordship.
It will be called on as per the order which I have passed. Yes, next matter.
Item number 11.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Next paragraph, list the matter under the heading motion in the monthly combined list of April 2026.
My lord, may I submit, my lord, one thing, my lord. Item number 6, my lord, unfortunately, my lord, I missed it, my lord. Item number 6, my lord, it has been, my lord, monthly.
Yes.
I withdraw this application. Item number 6, my lord.
The matter was called on, you could not appear.
I'm sorry, my lord. I'm sorry, my lord. I could not appear. We were not at the time of call. I was here. Unfortunately, my lord. My lord, withdraw. I mean, I am paying withdraw this application. Monthly. My lord, withdraw. I am paying withdraw the application for.
Not today. Not today. Come back on Monday because other side may appear. He will lose his opportunity to appear before this court. Sixth not today.
My lord, get full loss. Item number 6, my lord. Get full loss. Get full loss. I mean, mistake. This is my fault.
Item number 12.
Number the statement. I am on behalf of the petitioner.
Yes.
Here is this affidavit service. My lord, my motorbike has been stolen in 2020. Immediately, I go to the appropriate police authority to lodge my complaint. Kindly page
2020. When it was stolen?
2020. New cause of action arise.
2020.
New cause of action arise to now in 26.
What is that?
Kindly page 4, para 6. The petitioner was extremely shocked after a long lapse of time on 30 January 2026 at about 2:23 p.m. He received a message on his mobile phone informing him that a challan has been issued against the aforesaid motorbike bearing registration number such and such, which clearly indicate that the said stolen motorbike is being used by some unknown person for unlawful purposes, and due to the unauthorized use, the concerned police authority and or challenging authority has issued and e-challan bearing number such and such, and also said message is further directed the petitioner to pay the fine amount by visiting official website such. Kindly annexure P3. Annexure P3.
Who knows that you yourself has given this, sold out this motorcycle or not?
Sold?
You yourself has sold out.
I went to the police.
Where is the, because it is after 5 years this has happened.
Yes. I went to the.
You may have sold out the motorcycle. Where is the proof?
My lord, kindly pay.
Show me any contemporaneous document that your motorcycle was stolen in 2020. Otherwise, it is happening. If somebody sells his vehicle and thereafter, if any case is registered or if there is a violation of traffic rules, then the message is to be sent to the erstwhile owner of the vehicle if name is not changed.
My lord,
with the RTO.
To the registered mobile number.
Yes.
My lord, kindly page 21. Concerned police authority give me these photographs. where it is also located the longitude and latitude of the photographs. And I have
That
submitted.
is from the system. I also get similar photographs with regard to my vehicle.
I have already lodged a complaint before 2000 in 2020 annexure P2. Kindly page 19 before the inspect.
Issue. Matter is affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. A case is made out on behalf of the petitioner.
May I indicate just one thing? Kindly have a look into prayer portion. Kindly have a look, my lord. Registration of an FIR, my lord. And in 2020, the document he is showing, my lord,
Now
that is not been supplied to us, my lord.
A case is made out. Have you registered?
No.
A case is made out on behalf of the petitioner that he had a motorcycle or he had a two-wheeler. He had a two-wheeler which was stolen which was stolen or lost.
Theft or lost. Theft or lost.
Which was stolen or lost on 21st August 2020. But contemporaneously, no complaint was lodged. Complaining of such incident which took place on 21st August 2020. Stop. Petitioner received a message on his mobile phone on 30th January 2026 from the concerned authority relating to his motorcycle which was stolen / lost on 21st August 2020. Stop. Petitioner prays for direction. Stop. Petitioner prays for direction. Petitioner lodged a complaint in the month of February 2026 before the concerned police authorities. Stop. It is submitted that till date, after filing complaints before the concerned police authorities, FIR has not been registered and prayer is made for registering FIR. And prayer is made for registering FIR. Next paragraph. State respondents are represented by land advocate who has opposed this writ petition on the count that two-wheeler was stolen or lost on 21st August 2020. But complaint was lodged
I have lodged it.
in the month of February 2026,
My lord,
which is after, which is precisely after 5 years. Next paragraph. A man of ordinary prudence would have filed complaint with the local police station in case of theft of his motorcycle, in case of theft of his two-wheeler. On 21st August 2020, just before such incident, and he would not have waited for 5 years to lodge such complaint. Such delay caused by the petitioner in approaching the police authorities complaining of theft of his two-wheeler, does not instill confidence in the mind of this court that whether it was at all a case of theft or not. Stop. After obtaining or after receiving message on his mobile, petitioner lodged complaint with the local police station in the month of February lodged complaint with the concerned police authorities in the month of February 2026, which may be afterthought. Stop. Therefore, court is not inclined to interfere in this petition. Next paragraph. Moreover, for registering FIR, writ petition is not maintainable, and in this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2007-6 ACC 171 within bracket Alu, Podensi and others versus Union of India and others. Next paragraph. Writ petition stands dismissed. Parties to urgent xerox certificate.
Item number 13.
Wait, please, your lordship, I beg to appear on behalf of the petitioner.
My lord,
The-
my lord, before start, my lord, I prayed 2 days time to file the report, my lord. Yesterday evening, I received the brief, my lord. 2 days time has been prayed.
No, they have partially complied, my lord. I'll just run.
So let them come with the report.
There's some urgency, my lord. Elections have been notified. No, it's pertaining to election, my lord. A candidate.
He will come back on he is praying for 2 days time. Let it be on
My
Wednesday.
prayer, my lord, my prayer is very simple. For filing of nomination, I have to indicate the total number of criminal cases
Pending against you. Yes,
Yes.
you mentioned this matter.
Yes. So I have, my
It's
lord,
taken up today.
I made a representation to the Calcutta police as well as to, my lord, the DG.
Inform the number of cases pending.
Yes, the Calcutta police yesterday night has already sent an information regarding registration of one case, my lord, against me. So, my lord, on Monday, my learned friend can come back with the remaining information. Then
Is there any other remaining case you believe?
in West Bengal. This is in
Before the Bengal police.
Yes. So I have made it before the DG and IG and before the Commissioner of Police. The Commissioner of Kolkata Police has responded for that.
Lordship, I am appearing for the Election Commission of India. We have forwarded it to the state. Lordship, they can come up with the list of, no report is required, they can come up with the list of cases itself from the DGP's office.
6th March 2026.
First page is the information, my lord, which they have furnished.
With reference to subject mentioned of
আচ্ছা, আমি জানি না আমাদের
You apprehend that some other cases may
But
be pending
going by the trend,
or
my
may,
lord, as a member of
some other
Legislative
cases
Assembly.
are there before the
Yes, yes, there are very many, my lord. What is happening in respect of now, my lord, the police is executing the warrants. So various cases, my lord, of maybe of 2020, etc. We are now receiving warrants, my lord, in respect of some other leaders, my lord. So unless and until we know, my lord, because there is a bounden duty, my lord, under the provisions of Section 33A of the Representation of People Act.
to
my lord,
disclose
yes. Now in respect of,
all
my lord,
the pending criminal prosecution
yes.
cases.
Now, in respect of the no due certificate, there is a circular of the ECI which says that once the candidate applies after notification of the election or after the model code of conduct comes into force, the department has
What is the last date of filing nomination?
my lord, 30th of March, my lord, the nomination papers will be issued, my lord.
Oh.
And the last date is on the 6th of April, my lord.
First phase is 6th of April and second phase 9th of April.
Issue. Affidavit service.
Yes.
Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph, Mr. Bilodol Bhattacharjee, learned senior advocate representing the petitioner, submits that after filing this writ petition, that the petitioner is that petitioner.
I happen to be, my lord, the MLA from Moina Assembly constituency, and I am, my lord, a former player of the Indian cricket team, my lord.
Petitioner is a member of the Legislative Assembly and belong to a particular political party, and petitioner desires to contest the ensuing assembly election 2026 from being a candidate of the political party, of a political party. Next paragraph, present writ petition is filed seeking direction upon the concerned police authorities to intimate the petitioner the number of criminal proceedings pending against him. Stop. Next paragraph, it is also submitted on behalf of the petitioner that vide memo dated 19 March 2026, Commissioner of Police Kolkata informed the learned advocate for the petitioner that one criminal proceeding being Newmarket Police Station case number 138 dated 11th August 2025 under certain provisions of BNS is pending against the petitioner. However, it is submitted that concerned authority of Bengal Police, West Bengal Police is required to intimate the petitioners if any criminal proceeding is pending against him as on date or not. Next paragraph, learned advocate representing the state respondents has prayed for accommodation to obtain instructions. Next paragraph, concerned authority of West Bengal Police is directed to file a report before this court on the next date, disclosing if any criminal proceeding is pending against the petitioner or not.
The respondent number 2 may be directed, my lord. Made it before the respondent number 2 only.
My lord, there is a SP Purbo Midnapur as well as the Commissioner of Police, Calcutta Police.
Commissioner of Calcutta has already responded yesterday.
I have directed the concerned authority of this
My lord, SP Purbo Midnapur.
list the matter
throughout
under
West
the
Bengal.
list the matter under the same heading for further consideration on
Throughout West Bengal.
next Friday.
Next Friday কত তারিখ?
27th.
27th, my lord, there is some uncertainty, my lord, about the holiday, whether it's on the 26th or on the 27th. So, my lord, may kindly, my lord, take it up on next.
25th March.
25th. Extremely grateful. Extremely grateful. My lord, may it appear retain its position in the list?
Yes, supplementary list. Grateful. Please call the list.
Item number 14.
My lord, in this matter, I am led by Mr. Shubhi Shannal, the senior advocate. And this matter pertains to the taking out of a religious procession on the day of Ram Navami, that is on 26th of March. My lord, this is in Howrah. Lord, for a considerable period of time, this body had been taking out Ram Navami processions, and admittedly in 2023, certain disturbances took place, as a result of which in 2024, the police raised an objection with regard to taking of this procession, and they suggested that the route through which this procession goes, that is a very sensitive route, and so the route may be diverted. Other than this, certain other conditions were imposed, whereby the number of participants and certain other conditions were placed. Now, this matter came up before this Honorable Court, and this Honorable Court directed the holding of the said procession on the same traditional route which has been followed, and certain objection and certain conditions were drafted in the order which I will place before your lordship. But the next year, that is on 2025, again, when a permission was sought for from the police authorities, a similar objection was raised, and that was again taken up by this Honorable Court, and this Honorable Court passed a direction whereby the procession was held. Now, after the procession was held, the police, they alleged that so far as the timing of the procession was concerned, the Honorable High Court had directed the holding of the procession from 3 p.m. to 6 p.m. That was admittedly, the procession started at around 3:45 p.m. and it concluded around 6:30 to 7. Well, after this order, which was passed by the Honorable High Court, we had widely publicized the same, stating that as per the direction of the Honorable High Court, there will be only 500 participants. We had given the names of all the persons who would participate from our organization before the police authorities. We had given their numbers. We had given the names of the 10 persons who would be the responsible persons. Well, the allegation is that the 500 number, which was there after the procession started, that increased. But subsequently, an FIR was lodged with the Honorable High Court, disposed of the writ petition by directing that whatever FIR is, that is to be taken up before the criminal court. Now, this year again, I have prayed for a permission to hold the rally. Now, the police authorities, they have stated that yes, you can hold the rally. I have stated that the number will be 2,000. They have stated that it should be 500.
As it was in the previous year.
In the previous year. And the timing is also more or less, it was 3. They have stated to be that it should be at 3. We have stated at 5 p.m. But the major contention is again one which has been which is being raised for the last 2 years. That is the route. They have again modified the route. They say that you start from this point, go from that point. So this is the main point of contention which is before this Honorable Court. May I first place the order which has been passed in 2023 by this Honorable Court?
Show me the order, last year order.
Last year's order. The Lordship kindly comes to page 45, it starts. The key code. Huh? My lord, has your Lordship got it? Page 45. My lord, the relevant page is, my lord, page 47 if your Lordship kindly comes. and then 48. The following order the না হ্যাঁ করবো না আমি বললাম যে কি করছি তুই কর না তুই ওই তুই লাস্ট ইয়ারের অর্ডার দেখো লাস্ট ইয়ারের অর্ডারটা করছে আগে তো পাবো আমি আছি আমার ব্যক্তিগত মত যে প্রসেশন করতে চাইছে এত এই করতে একটা তুমি দেখতে পারবে যে যে কারণে পারমিশন দেয় না সেটা হুম 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 তোমাদের তো ওই হচ্ছে কাজ হয়ে গেল
Yes.
Now, after this order was passed, your lordship kindly comes to page 51. My lord, I gave the names of the 10 persons who would be the responsible persons as per direction of the Honorable Court. And then from the next page, I gave the names of all the participants who would be there on behalf of the association in that rally. My lord, thereafter, your lordship kindly comes to page 57. I widely publicize the order of the Honorable Court. It is 57 is in Bengali and 58 is in Hindi, where I have specifically mentioned that in terms of the order, the number should be restricted to 500, and we have requested all the members of the general public not to participate. But so far as this, after the matter which was thereafter, your lordship kindly comes to the order which was passed on 23rd of June. That is not annexed with this petition. That is, this is the final order which has been passed by the Honorable Court. When the matter again came up,
Yes.
Now, this year, I have, if your lordship kindly comes to page 67, is my application for seeking permission for this year. I have again stated what will be the who will be the participants and all these things, and I have also annexed a map which your lordship will find at page 70. From where it will start, where it will end, the traditional route which has been followed for so many years.
Same route.
Same route. Now your lordship kindly comes to page 72, which is the reply by the police authorities.
Yes.
If your lordship kindly comes to the bottom of that page 72, here the police authorities have stated the violations in short. May I read out?
Just a minute. Yes. So they suggested diverted route.
Now, they suggested some conditions, 5 conditions, and a diverted route. My lord, your lordship kindly sees the reply which has been given by me, that is at page 74. So far as the conditions which they have stated, 1, 2, which is enumerated as 1, 2, 3, 4, 5 at the bottom of page 73, I have got no objection to this. I am ready and willing to observe all these conditions which has been given.
Yes.
My only submission is that
route,
this route which has been followed for the last over 13-15 years, this is the traditional route which has been followed for years together, and so we are only on that count before this honorable court. Just as in earlier years, we
Yes,
have
Mr. Doctor.
Well, just may I, with your lordship's leave, Lord, I request your lordships, we will stick to your lordships, the last order passed by this honorable court on 4th April 2020.
Maintaining the route.
Maintaining the rules, and the route was maintained, what we prayed for. The last order passed by this honorable court at
page 45.
61 or twice annexed. My lord, we stuck to this same order. Now, every time this sort of objection comes from the state, every time your lawsuits will find. But for the last 20 years, we are following this route. I take your lawsuits to the this time, page 72, the objection of the state.
Yes.
Kindly see, during the said rally had violation of the conditions. Rally was supposed to be started at 3 p.m. to 6 p.m. Started 3:45 p.m. ended in 17:45 p.m. Now, my lord, I just tell you, my lord, submit before a lawsuits. Suppose this has happened. Has this caused any prejudice to anyone? My lord, a rally starts, my lord, it always 10-15 minutes either before or after. It's not so violent, even if, according to me, this has not. Now, next. At the en route procession, the party is supposed to exceed 50%, but the rally more than 5,000. Lord, we again stick, my lord, we given all the details of 500. Now, an exuberant Hindu joins us. It is for them to prevent him, not for us. My lord, say Durga Puja procession from my club or para goes to Ghat of Ganga. So only the people of the para remains initially. If somebody joins in the midst of this, well, it's for them to prevent them. It's not for us. We have given all particulars of 500, those who will organize the rally and go there. And third, one vehicle was allowed. Many participated in the rally with motorcycles. Well, this was not one of that. Vehicle was only one. And the last losses, I think this is the only objection. Now your lawsuit has to test it under the guidance of the Constitution. Kindly have a look at lawsuit, page 73, third paragraph. Furthermore, further, the stretch of Kajipara to Mollik Photo, has you also got that one, on GT Road has been assessed to be sensitive from the point of view of maintenance of public order and communal harmony in the light of past incidents reported during similar processions. But I find this was not recorded. This was the last occasion or last year, the same objection. If I'm not wrong, the views of the learned judge, honorable judge, can the state come up?
The order
with
was
this?
appealed against.
No, can the state come up with this? Sensitive because of communal reason. Some particular community is probably majority. For that minority community in that area will not take out any procession. Is it the constitution, my lord? Suppose a area is lordships inhabited by the Hindu persons. That doesn't mean the other community will not take out its possession and carry out to that area. That cannot be a ground. So this discloses the state stand that because of these they cannot allow, not those grounds, your lordships. Lord, kindly allow us to follow the earlier order if your lordship. That's
Yes,
enough.
Mr. Doctor.
I'm taking your lordship's leave.
My lord, the first point is, my lord, whether the court will allow its order to be violated like it was done in the previous years. But I'll demonstrate that. Please first take the order of 15th of April 2024 of Justice Sengupta.
Page.
Page 24 it starts.
Yes.
My lord, your lordship will kindly take, my lord, the third page of the order.
Yes. Internal page 3.
Yes.
Page 3.
Or if I may start from, my lord, the second page, last paragraph. Learned counsel for the representing the petitioner submits as follows. The petition number 1 is an organization, so and so. Petition number is so and so. The petitioners, last line, want to organize Ram Navami Shobha Yatra, where the followers of Lord Rama will participate in the religious procession. It will be conducted on so and so, between so and so. Similar rally has been conducted by the petitioners for the last 17 years. The petitioner would limit the number of participants at a time to 200. Now, this is what is being suggested before the court. The march will begin from so and so place to so and so. It will pass through so and so. After an application to this effect was made to the police, The police suggested an alternative route, citing law and order reason and asking the petitioner to follow a route after Kajipara through the Foreshore Road and then end their march at Ramkrishnapur Ghat. This will render the procession infructuous because Foreshore Road mainly has godowns and warehouses in its way. It is hardly a residential area where people staying could come out as on GT Road to Garland, Lord Rama, etc. This is what would be done. Now kindly take the submission of the state in page 4. Learned senior counsel representing the state relies on the report and submits. First, at present, Foreshore Road also houses residential building, etc. The alternative route would have been easier to manage. No permission has been granted to other organizations, which the petitioners have referred to as owing allegiance to the ruling political dispensation to hold such procession or rally on the date and at the same route. Last year, this is what was told to the court. Last year, when the petitioners had taken out such procession, they were having 10 to 15,000 participants. There were several offences committed on that day. Criminal cases had to be started inter alia under section so and so and other provisions of law. There are photographs of some of the participants belonging to the petitioners' organization vandalizing the area on that day last year. Subsequently, a division bench of this court transferred all investigations to NIA. The division bench, in fact, granted liberty to the state to alter the route to be taken by the participants. If necessary, the state has in fact allowed several other rallies in the Howrah district itself on the occasion of Ram Navami. This year, due to ensuing elections, the state is having dearth of forces even to manage a contingent of 200 participants. Then, the Additional Solicitor General makes his submission. Then, kindly take page 5. How the court is being misled. Second paragraph. Had it been the case that the petitioner wanted 10,000 to 15,000
Page 5, internal page 5.
Internal page 5, Second paragraph. Second paragraph. Had it been the case that the petitioners wanted 10,000 to 15,000 participants of their organization to pass through the area, a portion of which has been described as sensitive by the state, the court could have thought about the alternative route. However, a total number of 200 participants would be quite manageable to pass through any area in the state without leading to any untoward incident. We're pausing here for a moment. Please recollect, the last submission of Mr. Shannal, that if the exuberant people join the crowd, then it is my duty to stop them. Is it possible? Is this suggestion possible? Can the police stand over there, count head, and say that you are not entitled to
At the
participate?
place where it is indicated in the communication of the police authority that the nearby place election activities preparedness is going on.
Yes.
In that event, you depute more police personnel to check any incident if it happens.
Yes.
But once it is the court permitted 500% to join the rally. Why
And if there is 5,000, what
and it appears from the materials available on record that this procession was not restricted to, could not be restricted to 500. What is the use of restricting it to 200, Mr. Dotto?
Yes, yes. We are going by the court's order.
Yes.
Question is, whether the petitioners are going by the court's order or not. That's why I started by saying, will the court allow its orders to be violated? Now, first is, here, it was suggested before the court that it is a mere few hundreds. Therefore, there should not be any difficulty for the police to manage the area. But finally, they do not stick to that. I'll demonstrate as I go by. Now, please take, the next paragraph. Everyone has a right to express himself or exercise his right to practice religion. So and so, I do not say anything on that. Therefore, the court says, at the last paragraph at page 5, at any point of time, the total number of participants shall not exceed a number of about 200. In order to ensure that the number of participants is limited to 200, the petitioner shall make every necessary announcement and issue leaflets if required. The organizers shall nominate 5 persons from amongst themselves who
Doctor, what court is saying that yes, you are rightly pointing out that in terms of the judgment dated 15th April 2024, it was restricted to 200. Now it was subsequently enhanced to 500. Now in the with the 500 persons, this rally was organized, but there was there was an allegation. So for the administration as well as the police authorities concerned, that it was not restricted to 500. So the number of persons who joined the rally increased substantially. Now, taking note of the order passed by the coordinate bench in the last year, is it advisable to bring down the number of persons from 500 to 200? What is the use of it? There will be further opportunity or avenues to violate the order of the court.
Right.
Because it will not be, practically it will not be possible to maintain or the numbers of persons who will attend the rally to the number which is to be stipulated in the order to be passed by this court.
Right. But I absolutely right. But therefore, please consider whether, my lord, the court's jurisdiction can be invoked in these sort of matters, where, my lord, neither can the petitioner control the crowd, and on the other hand, blame the police by saying that why are you not managing the crowd? Therefore, my lord, please consider, my lord, whether two things, two primary things, my lord, requires, my lord, your lordship's consideration. First is, my lord, whether the police has a say in regulating these possessions or not. But the answer is yes. The second is, which the Supreme Court Constitution Bench has considered, is that does anyone have a right to organize any procession at any place of their choice on any particular day, and that the police has to grant permission. But the Constitution Bench has negated these ideas. The Constitution Bench has said that this is a wrong idea. Please have a look at this judgment.
But it is not a fact, Mr. Dotto, that only these processions are being organized by the organizers in the state. Other processions are also organized.
Yes, we are
also organized. So
what
therefore, in
happens
order
is-
to strike a balance and a pragmatic stand has to be taken.
Yes, definitely. But
I
may
could understand, court could understand if there is no procession which is being permitted or no gathering is being permitted. But this is not the fact situation so far our state is concerned.
But I have not prevented them from participating or organizing. I have said instead of route A, the starting point and the end point is the same. In between, my lord, I have asked for a detour. My lord, we have given two options to them.
Now think about from the court's point of view.
Yes.
Because you are relying upon the order dated 2024, 15th April 2024, it was restricted to 200 persons. Now subsequently it was enhanced in 2025 to 500 persons. Now with the 500 persons rally was organized.
No.
Yes.
More than 5,000. I have the.
That is, yes. That is the case so far the state is concerned, but court directed that it will be restricted to 500 persons. Now, today, is it apt to bring down the number of persons from 500 to 200?
My lord, whatever is the
Because
figure.
the previous precedents are to be weighed with this court. Today,
Therefore,
considering the respective submissions made on behalf of the parties.
Therefore, my lord, my respectful submission would be, my lord, the court's jurisdiction cannot be invoked in these matters for two primary reasons. Number one is, my lord, the previous orders of the courts have been violated.
You ought to have preferred appeal against the order
No,
passed on the
it's
previous
not required. My lord, we are not against organizing any rally.
Otherwise, Mr. Dotto, that order is binding upon me.
My lord, the Supreme Court orders are more binding on your lordship. My lord, I'll place the Supreme Court order. Please have a look to, my lord, 1970s. Okay. Well, Navarno Vision, my lord, our High Court has prevented only 2 months back. Please have a look to, my lord, Himmat Lal. Where the Supreme Court says, the Constitution Bench says that this is a wrong idea. Kindly have a look to, my 1973, Volume 1, Supreme Court cases 227. Well, unfortunately, my lord, these judgments are not placed for assistance of the court. Just give me 2 minutes, my lord. kindly, my lord, take, this is a long judgment. I'll not trouble you with the judgment in its entirety. What the Supreme Court says is very important. Kindly, my lord, take the points for consideration formulated by the Supreme Court at para 14. But here, my lord, a particular provision of the Bombay Police Act was under challenge on the ground that the police has been conferred with powers to prohibit processions. Now, please take, my lord, point number 2 and 3. Section 33(1)(o) of the Act is unconstitutional as it infringes Article 19(1)(a) and (b). The restrictions are wide enough to cover restrictions both within and without the limits of permissible legislative action affecting such rights. 3. In any event, the section and the... I'm sorry. Yes. Now, these are the questions framed, that we are concerned about point number 2 and 3. Now, please come to me, Lord, paragraph 31.
And 31. 31.
Yes, the Supreme Court is clear. It seems to us that it follows from the above discussion that in India, a citizen had before the Constitution a right to hold meetings on public streets subject to the control. This is very important, subject to the control of the appropriate authority regarding the time and place of the meeting and subject to consideration of public order. Therefore, we are unable to hold that the impugned rules are ultra vires so and so. Then point 2 and 3. This takes us to point 2 and 3 mentioned above. It is not surprising that the Constitution makers conferred a fundamental right on all citizens to assemble peaceably and without arms. While prior to coming into force of the Constitution, the right to assemble could have been abridged or taken away by law. Now that cannot be done except by imposing reasonable restriction within 1903. But it is urged that the right to assemble does not mean that the right can be exercised at any and every place. This is the first one.
So you are on reasonable restriction.
Yes.
Yes, that can be imposed.
Yes,
But
this is the reasonable
But
restriction.
this was considered, and the reasonable restrictions were there as it emanates from the order passed by the coordinate benches in the previous years. So without any restrictions, unbridled without any restrictions, straightway this order was not given that you organize the procession according to your own way. Court will definitely put certain restrictions as you are harping upon, relying upon this judgment of 1973 1 SCC. But what should be the nature of restrictions? Whether it is to be restricted to 200 or 300 or 3,000 or 5,000, it depends upon the situation which the court is considering, Mr. Dotto.
Well, my respectful submission is, please first consider whether, I have a right, the state has a right to impose this this restriction, condition that instead of route A, you follow route B. Now, if the state has the right, where I'll demonstrate from Himatlal, if the state has a right to say that don't follow a route A, go to route B, would the court entertain or not a petition where, my lord, the state has suggested a different route? Please permit me to place a few paragraphs because this needs to be done. Then please take me the next sentence in para 32. This court held in Railway Board versus Narinjan Singh that there is no fundamental right for anyone to hold meeting in government premises. It was observed that the fact that the citizens of this country have a freedom of speech, freedom to assemble peaceably, and freedom to form association or union does not mean that they can exercise those freedoms in whatever place they please. This is not a right. Now, kindly take me to the next paragraph. This is true that it is true, but nevertheless, the state cannot, I'm sorry, Yes, state cannot by law abridge or take away the right of assembly by prohibiting assembly on every public street or public place. The state can only make regulations in aid of the right of assembly of each citizen and only impose reasonable restriction in the interest of public order. This is what I've done. I've said that in the interest of public order, this area is sensitive. Please follow a different route. I have not prohibited, but this judgment says that I can prohibit also. I'll gradually, Miller, take your lordship to that. Then para
Mr.
34.
Doctor, these restrictions were also highlighted before the coordinate benches in the previous year.
Yes.
Now, taking this entire issue as well as the point of objections which were raised on behalf of the state respondents, court found that these are the restrictions which needs to be clamped for organizing this rally or procession. Now, why this will not be treated as a reasonable restrictions as decided by the court in the previous years?
Miller, reasonable, Miller, when the court, Miller, directs the issue of reasonable restriction does not arise. It is a mandamus, it is a mandate I have to follow. Miller, it's not, Miller, it is when your lordship directs anything, Miller, my lords are not exercising any power, for example, under Article 19.6. My lords are exercising the extraordinary writ jurisdiction, the constitutional power that has been conferred upon my lords. I have a right to challenge it, or else I have to follow it. I have followed it. I have followed it on the earlier two occasions, but I have found that whatever the court has directed has not been followed by them. It was for the court to take upon itself the consequences of the violation of the court's order, but I cannot say anything that neither my client has approached the court nor the court has suo motu taken cognizance, because the previous matter was posted for hearing after Miller the Ram Navami procession was over, and I'll place those orders where Miller the court noted that its order was violated, and the court said that you have lodged FIRs that will be taken care of. If they are affected, they are going to ask for quashing or challenge it. But please consider a few paragraphs of this judgment. Now please take paragraph 34.
Yes.
This court in Babulal Parathe rightly observed the right of citizens to take out procession or to hold public meetings flows from Article 19(1)(b) to assemble peaceably and without arms and right to move anywhere in the territory of India. If the right to hold public meetings flow from Article 19(1)(b) and 19(1)(d), it is obvious that the state cannot impose unreasonable restriction. Therefore, the first thing is my learned friends should come before the court and say that what I have said is an unreasonable restriction. It must be kept in mind that Article 19(1)(b) read with 13 protects citizens against state action. It has nothing to do with the right to assemble on private streets or property without the consent of owners or occupiers of the private properties. But I skip over 36, please take 37. We cannot appreciate how section so-and-so violates 19(1)(b). It enables the commissioner to make rules to regulate assemblies and processions. Without such rules, crowded public streets, it would be impossible for citizens to enjoy their various rights. Then, my lord, the Supreme Court is balancing the right. The Supreme Court has to balance the right of persons who are not before the court also. Someone is coming and saying that it is my right to assemble, good. But behind the screen, or the party who is not before the court are the ordinary citizens. There, my lord, the court has to also balance the rights of those who are not before the court. Please come to, my lord, paragraph 42 now. We may make it clear that there is nothing wrong in requiring previous permission to be obtained before holding a public meeting or on a public street, for the right which flows from Article 19(1)(b) is not a right to hold a meeting at any place and time. Now, please consider, my lord, pausing here for a moment. The petitioners are primarily asking for this, that I have done it for 20 years, 17 years, whatever years. Therefore, this year I also, I should be permitted to do that. But the Supreme Court says that you cannot choose the place and time. But I understand, Ram Navami has to be, procession has to come out on that particular day. There is no dispute on that. But it is not that I can come before the court and say that wherever I choose, whenever I choose, that has to be permitted. Then, my lord, I skip over, my lord, a few paragraphs.
Yes.
Now, my lord, now Justice Matthew, please take Justice Matthews, paragraph 60.
Yes.
It might not follow that because ABCD, etc., have a right to walk down the high street, they have a legal right to hold a public meeting. So and so versus so and so, which Dicey cites as leading case on the point of public meeting. But I skip over those. Now, please take note of the quoted portion at that page, the last paragraph of the quoted portion, where it starts with the notion. This is very important. The notion that there is such a right as a right of meeting in public place arises from more than one confusion or erroneous assumption. The right to public meeting, that is the right of all men to come together in a place where they may lawfully assemble for any lawful purpose and specially for political discussion, is confounded with totally different and falsely alleged right of every man to use the purpose of holding a meeting at any place which in any sense is open to the public. The two rights, did they both exist, are essentially different and in many countries are regulated by totally different rules. It is assumed that squares, streets, or roads, which every man may lawfully use, are necessarily available for holding of a meeting. The assumption is false. Well, this Dicey's, my lord, observation is upheld by the Supreme Court. What is always told before the court is that I have a right under 19(1)(a) and B. Therefore, I'll have a right to assemble in court number 5. That is a false right.
Yes.
But then, my lord, this Justice Matthews part has also concurred by Justice Beg at paragraph 82. Then Justice Beg's para 85, can you have a look? But the last 5 lines of para 85, please have a look. This is the clinching part. Whatever may be the law in America, we have not been shown any authority for the proposition that there is an unconditional right of holding a public meeting at every public place, much less of a public thoroughfare or street in this country, as a necessary incident of fundamental right of either free speech or assembly. Therefore, my lord, my respectful submission is that, my lord, here the state is not unreasonable by prohibiting the procession. What we are saying is,
Divert the route.
divert the route.
Restricted it is to.
Well, yes, with the starting point and the ending point is the same. But at a particular placement, I'm told it is the detour is about 100 meters, not much. It's not that I'm telling them to take a detour of 5 kilometers. Therefore, my lord,
Yes.
well, I can quite appreciate, my lord, what is passing through the mind of the court, that if the state has accepted the previous 2 years' orders, why should the same order not be passed this time?
I find that there is a dichotomy with regard to the stand is being taken on behalf of the state.
Yes.
In one hand, as it emanates, Mr. Dotto, from the communication dated 12 March 2026,
Yes.
that these are the restrictions which are required to be, or these are the change restrictions which are required to be
Right,
followed
right.
to organize such rally.
Yes.
But it is being argued on behalf of the states that this is not an absolute right as enshrined under Article 19(1) AB. So therefore, it may be cancelled. So where you strike the balance?
But my respectful submission is, my lord, number one, please consider whether somebody has a right to come up and say that I am going to organize a particular procession on this day from this place to that place, because it flows from Article 19(1)(a) or 19(1)(b).
B.
My lord, the Supreme Court has said in Himmat Lal that this assumption is wrong, false. And the Supreme Court has not been shown any law which says that this right has to be necessarily upheld. This is number one. Number two is, my lord, whether the state can impose reasonable restriction. Or in other words, to put it differently, in the facts of this case, is the restriction that the state has imposed, whether it is unreasonable or not. Please consider this. And number three is, my lord, I quite appreciate that Ram Navami procession has to be held on that day. Therefore, I cannot or I should not change the date or time. But can the state not, my lord, suggest an alternative route? But this suggesting an alternative route is only a reasonable restriction in aid of the public order. Now, I should take the blame upon myself that on the last two occasions, at least on the last occasion, I did not assist the court in the way I am trying to assist today. Possibly, if Himmatlal was placed, the order may not have been published, but be that as it may, I think I have a right to agitate this point at any point of time. Now, please take, my communication of 12th of March.
Forty-two is the clinching paragraph. So far, your contention is concerned.
But unfortunately,
now Mr. Dotto, you are making submissions from a particular point, based on a particular point of view. Then court has also is required to consider the restrictions which the state is trying to, or the state authorities are trying to impose vis-a-vis the stand taken by the by the coordinate benches.
Yes.
So
for that, yes, for
there lies the conflict.
For that, kindly have a look at page 72.
Page 72.
72.
This is wrong. This is wrong. Yes.
Please take the third paragraph. It's a detailed, my lord, order. In this regard, this is to state that it is a matter of record that during the Ram Navami rallies held on the above mentioned route in 2022 and 20.
Just a minute.
But I am on the third paragraph.
It is also noted that.
Yes.
Yes.
It is a matter of record that during Ram Navami Shobha
Telling page 72 dated 12 March 2026. That you were advised to the.
Yes, I think it's page 72. It's a memo number 124.
Yes.
Please take the third paragraph.
Third paragraph. It is also noted that.
No, that's the fourth. Oh, I'm so sorry. Well, it's the second paragraph. I'm so sorry.
Fourth paragraph.
No, I'm placing the second paragraph.
Second paragraph.
In this regard, it is to state that it is a matter of record that during Ram Navami Shobha rallies held on the above mentioned route in the years 22 and 23, incidents of communal violence were reported in the said area. In this connection with those incidents, several FIRs were registered and the matters are presently under investigation by the National Investigating Agency. In view of the above, permission to hold the said rally along the proposed route was not granted in the year 2025. It is also noted that you were advised at that time to consider organizing rally along an alternative route along so-and-so. The same was not taken into consideration by you. Subsequently, the Honorable High Court video order dated so-and-so was pleased to permit the rally to be taken on so-and-so along the route applied for, subject to compliance of the conditions imposed by the Honorable Court. However, during the said rally held on so-and-so, violations of the conditions imposed by the High Court were reported, namely one, the rally was supposed to start at 3 p.m. and 6 p.m., but it started from 3:45 and ended at 7:15. I don't have much grievance on that. Now, please take the second one. Though it was ordered by the Honorable High Court that at any point of time, en route procession, the participation was not supposed to exceed 500 participants, but the rally had more than 5,000 participants. Though only one vehicle was allowed, many participants had participated in the rally with motorcycles. Consequently, 2 FIRs were registered against you and other members of your organization with a case number such and such. It is further relevant to mention that the proposed route also passes through the vicinity of the Shibpur police line where regular activities relating to election preparedness, training of personnel and other administrative arrangements are being conducted.
Mr. Otto, we are regularly reading on newspaper about motorcycle rallies.
Again?
About motorcycle rallies.
Yes, motorcycle. Should be banned. Then,
So where is the uniform stand? So far the state is concerned. That that breaks the conscience of this court also.
yes,
Yes,
I'll tell you, Lordship, the figures that don't come to the court is the reason for which, the court sometimes, have a sort of a frame of mind. Hundreds and thousands of permissions are given every month. Those permissions don't come because they won't come to court. One who has been granted permission.
There is no requirement to come to
court. Only few, maybe 10 or 15 in a month throughout the state where it is rejected.
Dispute arises.
Yes, they come to court. Thousands permissions are given every month. Where I have those statistics with me. For one case, I brought those statistics, irrespective of political parties. Irrespective of political parties. We had a big gathering last week. Nobody came to court.
Well, Mr. Otto, I have heard you.
Yes.
Let me pass an order.
Yes. Therefore, my lord, please consider, my lord, my case is that I have not stopped. And
with certain restrictions which the state or organizations are found to be reasonable.
Yes.
And within the framework of the Article 19 of the Constitution.
And my lord, with this order, please have a look to the pleadings. Nowhere they have said that what we have said is wrong. I have checked up. Except saying that frivolous FIRs have been lodged, they have not even come on record saying that what we have said in page number in the order of 12th of March are incorrect, wrong. And Millard, let them pass through the alternative route, Millard. They have not said what is the difficulty. Millard, the case is that it is a traditional route where there cannot be anything called the traditional route. There cannot be, subject to correction. They say that they are holding it for 20 years. My officers dispute, be that as it may, even assuming for argument's sake that it is for 20 years, it cannot be a traditional route. What is meant by a traditional route? So the expression traditional route, Millard, in my very humble submission is a misnomer. Number one. And number two is, Millard, I have within the four corners of my right, Millard, suggested a route.
Yes.
Keeping in view the public order, but let them, Millard, adopt one of the routes. There's no difficulty in that. I can understand, Millard, that they say that I cannot hold any procession over there. There has to be a right to choose. That right to choose, in my very respectful submission, Millard, is not there. Please have a look at the very recent order of the division bench of our court. But kindly have a look to this recent order of the division bench where, Millard, the police had prohibited. This is a case, Shankar Ghosh, where the police had prohibited, Millard, processions, Millard, in the Navanno area. Millard, Himmatlal and others, Millard, has been considered. Paragraph 3, Millard, Himmatlal considered. Then please take, Millard, paragraph number 20. Please take paragraph 20 onwards. Shaheen Bagh and all, Millard, I am not troubling your lordship with all those judgments for the present.
20, yes.
Yes. If I may read from 19. In the case of Shaheen Bagh, the apex court again considered its previous judgment, including the judgment of Himmatlal and Ramdullah Madan, and came to hold that we cannot accept the plea of the applicants that an indeterminable number of people can assemble whenever they choose to protest. Merely because in the instant case the number of demonstrators is determinable, it does not give any indefeasible right to lodge demonstration at any particular time and place. The common string flowing from the aforesaid judgments of the Supreme Court shows that the state is empowered to impose reasonable restriction on demonstration. If in front of Navanno, the state headquarters, the demonstrations were not permitted, it cannot be said that the right to protest is taken away. We are unable to persuade ourselves with the line of argument of the learned senior counsel for the petitioner that declining permission to lodge protest.
Mr. Dotto, that is in front of the state headquarters.
Yes, yes.
How that can be
No,
related with the
it's a political
route in the district of Howrah?
May I say this, Millard?
And the point which is being taken for
the last 2
for
years.
detour is that the election work is going on and
Many
election
other points are there.
preparedness
Many other
and
points.
other points are. So therefore, how this
May I say this?
this
Why-
order will is relevant so far the present case is concerned.
Well, I'll tell
Because the
you.
consideration is completely different. It's a state
Absolutely.
headquarter.
But Millard, the purpose of placing this judgment is, Millard, this is Millard on a higher pedestal against those persons who claim that I can hold anything anywhere. Here, Millard, the state did not regulate. Here, the state prohibited, upheld. Whatever. Now, upheld for what reason? Upheld for on the ground that you do not have a right to hold any rally, procession, whether it is religious.
They are not to hold any program, any agitation or any rally in front of no one.
Yes.
But it is not the situation so far the present case is concerned.
Right.
Where you are saying that no, you can organize this rally, but through a different, following a different route and with a lesser number of persons.
Yes.
These are the two conditions which
Right,
are trying
right.
to impose.
Therefore, Millard, please consider, Millard, as your lordship has been pleased to, Millard, couch it in a sentence, Millard, whether the police has this power or not. If the police has this power, Millard, my respectful submission would be, Millard, this writ petition does not merit any order. Or else, Millard, if it is held against me that no, I cannot impose this restriction also or this regulation also, then Millard, I leave it to the court. Merely because on the previous 2 occasions, the orders were passed without considering Himmat Lal, but I don't think, Millard, the previous 2 orders will override Himmat Lal. Because in the previous 2 matters, Millard, in one of them, Millard, I have to take the responsibility on myself. The court was not assisted with Himmat Lal. Wherever the court has been assisted with Himmat Lal, like the unreported judgment, the court has stood by the power of the state. And please consider, which I am repeating over and over again, Millard, is it an unlawful exercise of power on the part of the state or not? My respectful submission, it is not, because I have to balance the rights of the parties who are not before the court also. The suggestion of Mr. Sanyal is devastating. That if the court permits 500, why have you allowed 5,000 people to assemble? Whom will I throw out from there? I just see the pictures. Yes. That's why I started by saying that whether, Millard, the court will permit again its order to be violated or not. Kindly look into these pictures. Last year. Last year. না, না।
এসো।
No, no, no.
কার দেখি দেখি আমাদের একটা কপি দিন বলে দুটো রামনবমী দুটো আছে কোনটা আমাদেরটা কিনা দেখি না না দুটো মামলাই হয়েছিল আমাদেরটা
এটা অ্যাপিয়ারেন্স Sure. May I take your lordship's leave so that I don't disturb your lordship anymore?
No, no. It's my pleasure to hear the Advocate General on behalf of the state respondents.
Okay.
ঠিক আছে দেওয়া দরকার থাকুক
এই ছবিটা দিন যাচ্ছে আজকে এইগুলো আমরা ওখানে ডিফারেন্ট ছবি দিচ্ছি
এগুলো হচ্ছে আগের
এটা দিন এই জন্য পার করে দিয়েছি দেখে নিন এটা দুটো একলা
Who is respondent number 2?
Respondent number 2 is Election Commission of India.
And no, petitioner number 2, sorry.
Petitioner number 2 is the secretary of this organization.
Vishwa Hindu Parishad.
Vishwa Hindu Parishad, Ram Navami Shobha Yatra Samiti.
Matter is heard at length in presence of the learned advocates representing the petitioner and state respondents. An organization, namely Vishwa Hindu Parishad and its secretary have approached before this court with the present writ petition, comma, inter alia, comma, praying for necessary directions upon the concerned police authorities, which would facilitate state organization, within bracket called state organization. Herein after referred to state organization, which would facilitate state organization to organize a Ram Navami rally on 26th March.
26th March, Your Lordship.
On 26th March 2026. Stop. Mr. Shanal, learned senior advocate representing the petitioners, ably assisted by Mr. Krishnendu Sarkar, learned advocate, has drawn attention of this court to the orders passed by coordinate bench on 4th April 2025 on a writ petition being WPA 7511 of 2025, centering around same issue. Stop. It is submitted that imposing certain restrictions, the coordinate bench in its order dated 4th April 2025 permitted the said organization to organize rally on Ram Navami day and as such in the present year 2 petitioner organization in the present year 2 said organization may be permitted to organize a rally on 26 March 2026 following the route which was followed in the previous year and followed in the previous year. Stop. It is submitted, it is also contended that the restrictions which were imposed by the coordinate bench in the order dated 4th April 2025 may be made applicable in organizing the rally in this year, in organizing the said rally in this year. Stop. Next paragraph. Petitioners, the said organization made an application dated 17th February 2026 addressed to the Commissioner of Police, Howrah City Police, Howrah, being respondent number
Respondent number 5, Your Lordship.
5, seeking permissions to organize rally on 26 March 2026. Stop. The application of the petitioner dated 17th, application of the said organization dated 17th February 2026 was responded to by the Assistant Commissioner of Police within bracket headquarter, Howrah Police Commissionerate, being respondent number 7. Being respondent number 7, VDA memo dated 12 March 2026. Stop. It was stated in the said memo dated 12 March 2026 that the time schedule of the rally was not appropriately maintained in 2025 and more than 500 participants participated in the rally in contravention of the order passed by the coordinate bench on 4th April 2026 and 4th April 2026. Stop. In addition thereto, it was also stated that though only one vehicle was permitted to be used in the rally, but apart from the said vehicle, motorcycles were found present in the said rally. Stop. Taking note, next paragraph, taking note of such alleged violations on the part of the said organization in conducting rally in 2025, violations of conditions. Sentence table ball. Such alleged violations of conditions imposed by the coordinate bench in the order dated 4th April 2025 taking note of alleged violations of conditions as imposed by the coordinate bench in the order dated 4th April 2025, concerned police authorities suggested change of route to organize the rally. Along with other conditions to be followed in 2026 rally, and accordingly said organization was directed to submit fresh application seeking permission. Next paragraph, it is contended on behalf of the petitioners that the route which was followed in 2025 was not a new route, but same alignment was followed while organizing the rally for number of years, and there is no justification so far police authorities are concerned to suggest alternative route to organize rally in 2026. Stop. Reliance is placed on the orders passed by the coordinate benches on order passed by the coordinate bench on 4th April 2025, and prayer is made that following the directions as contained in the said order in 2026, said organization may be permitted to organize the rally. Stop. Next paragraph. State respondents are represented by Mr. Kishore Dotto, Learned Advocate General, who oppose this writ petition based on the provisions as contained in Article 19(1) within bracket A and within bracket B vis-a-vis judgment of the Honorable Supreme Court reported in (1973)(1) SCC 227 within bracket Himat Lal K. Shah versus Commissioner of Police Ahmedabad and another. Stop. It is also submitted on behalf of the state respondents that police authorities did not negate the application of the petitioner seeking permission to organize rally, but certain restrictions were suggested for the year 2026 in view of ensuing election and to maintain peace during the period when the rally is to be organized. Stop. It is submitted in reference to Article 19(1)(a) and 1(b) that state authorities are empowered to impose reasonable restrictions, and so far present case is concerned, it was suggested that petitioners to follow the route as indicated in the memo dated 12 March 2026 by the respondent number 7, and the participants and the number of participants in the rally may not be more than 200. Stop. With regard to restricting 500, it is their case that in reference to the order passed by Justice Sengupta, whether it is stated in this memo dated 12 March 2026
Yes,
that
ma'am.
it ought not to be more than 500.
Yes, my lord. 73.3, page 73.3. The total number of participants will not exceed 500.
আচ্ছা, তাহলে এই সেন্টেন্সটা পড়ো ঠিক করে। But in the order of Justice Sengupta, it was
200. Subsequently, in 2024, it was 200. In 25, it was 500.
পড়ো। Route and number of participants. Number of participants as indicated in the memo dated 12 March 2026 issued by the respondent number 7. In this regard, reliance is also placed on the judgment of another coordinate bench dated 15th April 2024, passed on a writ petition being WPA 9937 of 2024, when the coordinate bench was considering the rally to be organized by the said organization in 2024. It was submitted by the Learned Advocate General that in terms of the said judgment dated 15th April 2024, number of participants in the rally was restricted to 200. Stop. Therefore, Therefore, it was submitted on behalf of the state respondents that considering the situation prevailing at the material point of time, it is within the domain of the police authorities to impose certain restrictions which does not find fault with the provisions as enshrined under Article 19(1) within bracket A and within bracket 1B of the Constitution of India. Stop. In order to buttress such submission, reliance is placed on paragraph 42 of the judgment. Reliance is placed on paragraph 42 of Himat Lal Supra. Stop. Next paragraph. Taking note of the submissions made on behalf of the made on behalf of the state respondents. Taking note of the submissions made on behalf of the state respondents, and on perusing memo dated 12th March 2026 issued by the respondent number 7, it appears that though police authorities have not disallowed the application of the said organization seeking to praying for permission to organize rally on Ram Navami Day in 2026, but authorities suggested chiefly two restrictions: one, to change the route, and number of participants in the said rally should be needs to be restricted to 500 and not more than that. Next paragraph. As it is contended on behalf of said organization that it is ready to adhere to the conditions as imposed by the coordinate bench in the order dated 4th April 2025, and in the said order, number of participants in the rally was also restricted to 500. Court finds that in this year Ram Navami rally, in this year, while organizing Ram Navami rally, number of participants needs to be restricted to 500 and not more than that. Next paragraph. Question is whether the route, whether a different route suggested by the respondent number 7 in the memo dated 12th March 2026 is required to be followed or not. Stop. This court cannot brush aside the fact that in previous years, said organization conducted rally following the route which is to be followed in the which is to be followed in 2026 as it was applied for while seeking permission vide application dated 17th February 2026. Moreover, the coordinate bench on an identical situation permitted the petitioner permitted the said organization to follow the identical route. Stop. The order dated 4th April 2025 was not appealed against, and the same attained finality. Next paragraph. as per paragraph 42 of Himat Lal Supra, right as enshrined under Article 19(1)(b) can be regulated in the interest of all, so that all can enjoy the right. Stop. Such observation of the Honorable Supreme Court needs to be considered on the basis of the reasons assigned in memo dated 12 March 2026 by the respondent number 7 for changing the route for the year 2026 in order to organize said rally. Stop. Two reasons are assigned. -1, as the proposed route falls on the area which is beside Shivpur police line, where regular activities related to election preparedness, training of personnel and other administrative arrangements are being conducted. And the said rally may hamper these essential activities. (2) Stretch from Kazipara to Mollik Photok on GT Road was assessed to be sensitive from the point of view of maintenance of public order and communal harmony in the considering the past incidents. Stop. Both the issues can be addressed. Now, both the concerns highlighted by the respondent number 7 in the memo dated 12 March 2026 can be addressed appropriately by giving direction upon the police authorities to depute adequate police personnel at the place where election activities are going on. Both the issue corona, sentence take by point. Now, the concern highlighted relating to election can be addressed. বলে বাকিটা যা আছে তাই। so far sensitive area as demonstrated in the said memo dated 12 March 2026 requiring change of route is found to be not tenable, since following the same route on in previous years, procession was organized in terms of the order passed by the coordinating bench. Stop. Next paragraph. Therefore, the next paragraph. Therefore, the observations contained in Article 42. Therefore, the observation contained in paragraph 42 of Himatlal Supra should not be construed to stand in the way in permitting the said organization to hold rally on Ram Navami day, if the restrictions which were imposed in the previous year are followed. Next paragraph. Hence, court permits the said organization to organize rally following the same route which was followed in the previous year, subject to following conditions. So Roman 1. Total number of participants in the rally at no point of time shall exceed 500. Stop. In order to ensure that number of participants in the rally is restricted to 500, said organization shall disseminate information by distributing leaflets and utilizing public announcement system. 2. Said organization shall appoint, or said organization shall depute 15 members, or shall depute 15 persons who are members of the said organization, who shall be responsible for conducting for organizing the procession. 3. No mobile number. Mobile number. Otherwise, we cannot find out the mobile number. Stop. The mobile ওখানে দিয়ে দাও একটা যেমন বলছে the mobile numbers of those 15 persons shall be shared with the concerned police authorities. Stop. 3. No vehicle shall be permitted in the said rally except one which would carry tableau and the idol of Lord Rama. এটা পেয়ে যাবে, হ্যাঁ, কন্ডিশন গুলো মোর অর লেস সেমই। নেক্সট, participants shall not carry or brandish any arms and weapons. Participants shall not shout slogans which shall incite communal tension. Next, participants shall not carry in the procession any stick, lathi, weapon. Stop. However, they will be allowed to carry flags and or any other symbolic weapons which should be only made of PVC. Full stop. Stop. Police authority shall be at liberty to take necessary steps if any metal weapon is displayed in the rally. Next, participants shall also abide by the relevant pollution norms, including sound limits. Stop.
They will not.
Normals. Stop. Only normals, it is there in the previous year. Only normal sound system, that is 5/6 microphones, be allowed to be used in the processor.
Yes.
There are two or three conditions.
Yes.
Page কত বলো?
Page 73.
Page 73.
Sure.
Page 73.
Yes.
No provocative abuse, violence.
Just a minute. Let me come to page 73. Yes. No. Page 73.
Yes, Lordship, that 5 conditions at the bottom.
Number 2, number 4 and number 3.
Shall furnish full details of the VIP shall no VIP shall participate. Yes, no VIP.
They have to communicate, otherwise you cannot.
বলে দেবো আমরা, বলে দেবো আগে।
Your Lordship, no, someone is not actually doing it, not
If that is 5/6 microphones be allowed to be used in the procession.
We do not use any DJ also. Last year also there was no DJ.
একটা জিনিস করে দাও, the participants, the rally organizer or participants shall not use DJ.
Yes. We don't do that also.
Yes. Because if you use DJ, then it will violate sound norms.
Yes. That we always observe in every time we see DJs are a menace.
Next, participants in the procession shall not halt or pause at any place or would continue to gradually proceed towards their final destination. Stop. Next paragraph. In the event there is violation of the conditions stipulated herein above, police authorities would be at liberty to take steps in accordance with law. Stop. Just a minute, just a minute. Police authorities shall also be at liberty to utilize vehicles which will be escorting at the front and back of the procession. Adequate trained police personnel to be deputed to maintain law and order during the period when rally is to be organized. Next paragraph. The procession will start at 3 p.m. and would take and all efforts shall be made to complete the procession by 6 p.m. on 26th March 2026.
May I suggest only one thing? Instead of 3 to 6, whether it can be changed to 4 to 7, Your Lordship. Only one.
Only one.
But you have applied in your application 3 to 6.
Yes, 3 to 6 I have applied. I don't deny that.
That will change your application.
No, in my application.
In your application, show me that you have applied. In your application, show me.
Your Lordship,
that you have applied for the timing or schedule from 4 to 6
let me
instead
just,
of 3 to 5.
The Lordship kindly allows me to.
Yes.
Yes.
Show me.
I have stated in my application, which is at page 67, Your Lordship, I have stated from 4:30 p.m. to 8 p.m.
Since I am permitting you to follow the same route as it was followed in the previous year, so other norms to be followed. Don't change; it will create confusion and also create problems.
All right.
So for organizers or no, I am not allowing you.
That is there.
It is advisable to conduct the rally during daylight.
Yes. What has fallen from Your Lordship, we shall observe that only. That is there.
So we'll start from 3 p.m. and we'll কি বললাম and
এবারে তোমরা একটা কেস করেছিলে সেটা সেট হয়ে গেছে তোমরা ফলস কেস দাও
next paragraph. The name of 500 participants with their identity card, either
জয় বাংলা বল
name of photo identity card will be sufficient. Name of 500 participants with their photo identity cards. Will be submitted before the Deputy Commissioner of Police Central Division, Howrah, being respondent number?
No. It is respondent number
Deputy
6, Your Lordship. Deputy Commissioner of Police Central Division is 6.
Before the Deputy Commissioner of Police Central Division, Howrah, being respondent number 6. Prior to organizing the rally. Stop. Next paragraph. Prior to organizing the rally. Stop. Next paragraph. It is difficult. It is difficult.
6 hours, 5 hours.
Before organizing the rally, it is to be. Because otherwise there will be a lot of confusion.
But they will make the
Next, the compliance report be submitted before this court on it is to be organized on 26th March.
26th of March, Your Lordship.
4 or 5 hours starting. Otherwise, how can we know who are the 500?
26th. On 1st April 2026. On 1st April 2026. Stop.
ওদিনকে compliance report দেবে হ্যাঁ আপনারা দেবেন
When this matter will appear under the heading to be mentioned. Next paragraph. All parties shall act on the server copy of the order duly downloaded from the official website.
Only with
Last year, I cannot take in a blood, there are so many dignitaries, 3 or 4. The enjoying the blood, the get categories and Y categories. Here were also blood joining the.
How court can restrict them?
No, not restrict, I am not restricting. To inform us. To inform us, they will also join.
So that this 500 includes those participants.
Yes,
So I have already directed. So there should not be any further direction with regard to. I am telling Mr. Banerjee that will create confusion.
For them, state has some responsibility because they are enjoying the category Y category.
My lord, so far as the status of the petitioner number 2 is concerned, he is, my lord, I have stated secretary, he is not the secretary, he is the president.
Oh, the president.
Kindly.
Is it possible to know in all such kind of rally that who will participate and who will not participate? Miss Shaw, I am keeping this book. After signing this order, you will get it. No, I have marked it by pencil. You will not get it now.
Affidavit of service.
Erase it and then you will get it. 1st of April.
1st of April.
So let it appear. Let me see that what are the issues. If any issues are there to be, Mr. Today I am not. That's why today I am not disposing of. Let matter come up on 1st of April. If you highlight any issue, then accordingly an order is to be passed. You highlight the issues. What will happen? You cannot apprehend. You cannot comprehend now. You cannot anticipate now. So why you are now taking that anything will happen and that requires a filing of compliance report? You highlight this issue on the next date based on which matter is to be considered. No, not at this stage. Let it come up.
Later.
You highlight those issues on 1st April. April has to be mentioned.
My lord, affidavit of service we kept on record. Grateful.
Please call the list.
Item number 15.
For the petitioner, my lord, this is the affidavit of service, my lord. Revans of
What about the private
petitioner.
respondents?
My lord, I have served them.
From 2 p.m., what about the private respondent? Otherwise, I will not hear you if all parties are not present. Because there is a resolution.
But learned counsel for the state is there, my lord.
Not
Only
today. Not
interim,
today.
my lord, some extent benefit. My lord, tomorrow
Come
is
back on Monday, it will retain its
tomorrow is
position.
the Eid, my lord. I am restrained from entering my house.
Very well, not today. Yes, next.
Item number 23 for monthly list of appellate side.
Not today.
Item number 156.
Go on calling.
157. 158. 159. 160. 161. 162. 163. 164. 165. 166. 167. 168. 169.
Not today. No, sorry. Not today.
170. 171.
The petition amendment.
Not today.
172. 173. 174. 175. 176.
আপনি কি পিটিশনারের হয়ে
আমি নিজেই পার্সন হয়ে কেসটা
আদার সাইড কোথায়?
হ্যাঁ
আদার সাইড কোথায়?
আদার সাইড তো আমি বলতে
আজকে তাহলে নট টুডে হবে। আজকে অসুবিধা আছে আদার সাইড সেটা বলা মুশকিল, লিস্টে থাকবে পরপর রোজই ডাকা হচ্ছে কম্বাইন্ড লিস্ট।
177. 178. 179. 180.
180 am for the petitioner.
Not today.
181. 182. 183. 184. 185. 186. 187. 188. 189. 190. 191. 192. 193. 194. 195. 196. 197. 198. 199. 200. 201. 202.
Not today.
203. 204. 205. 206. 207. 208. 209. 210. 211. 212.
দেখো